Hello everybody and welcome to this new Privacy Rules podcast series. Today we are going to discuss with a special guest that is Jordan Fischer. Jordan Fischer is a lawyer from the law firm XPan Law Group in New York, and we are going to discuss today a bit about the New York Shield Act and what it is and where it comes from. In fact, in the United States, lots of new regulations are popping up in relation to privacy and data protection. This is not the first, this is not going to be the last, but for sure it's going to be interesting to see which are its main differences with the regulation that we already faced, like the CCPA and the GDPR in the European Union. So without further delay, I would like to thank again Jordan for being with us today, and I would like to start asking what is the New York Shield Act and how it works?
Great, well thanks. I'm happy to be here to talk about it. I think you set it up so well, which is that in the United States, we are going through this evolution when it comes to the legal frameworks in privacy and cybersecurity. In the last 2 years, we have just seen almost every single state consider changing, propose changes to regulations. And like you said, California has dominated much of that national and even global conversation from a US side, but they're not the only state that is actively looking to regulate privacy. And as you said, New York has a legislation that is going to go into effect March of this year, so March of 2020. It's called the New York Shield Act, and it is going to require companies to take proactive measures when it comes to securing the technical, administrative safeguards that they use around the data that they're collecting. Now, similar to how we're seeing other regulations, it's really aimed at protecting New York resident or New York citizen data, but it has an extraterritorial impact because you could be a business doing business in New York and collecting that data and not necessarily even physically being in New York. So it sort of has some similarities that we're seeing in other regulations, but because it's on the books and it's going into effect in March, it's something that a lot of companies need to be aware of, especially if you're doing work on the East Coast or in New York generally.
Okay, and thank you very much for this brief introduction, Jonah. And specifically, which are the main characteristics of this regulation? How it's structured?
So there's two main sort of components to be aware of as a business. The first is that it changed and broadened the definition of what is personal information that can create liability around a cyber breach. So in typical US law, a personal information that creates that liability in cyber breach is often a name plus a social security number, or a name plus this other like financial information. And New York, among many other states, has taken a new look at that and extended the definition of what is going to be considered personally identifiable information to much broader pieces of data. So the reason that's so important is because so many companies now are going to have data that if it's impacted by a breach is going to require them to notify, right? And notification creates liability and sort of has a spiraling down impact. So that's impact number one under the regulation. The second one, which I think is more impactful from a compliance governance standpoint, is that you now need to proactively put together administrative, technological safeguards to protect data. So you need to be able to show that you're taking reasonable measures to protect information that you're collecting. What those reasonable measures are going to look like is very vague under the regulation. So it's going to be up for a lot of interpretation. And this is what we see commonly in most regulations because the compliance world can change so drastically, and they don't want to say everyone has to encrypt at this level because in 6 months that's going to be old news and there's new technology out there. But it's more that companies are going to have to go through the exercise of what data do I have, how am I protecting it, and is this going to be deemed reasonable, right? This very amorphous term, reasonable. So it's still like you're going to want to look to standards, you're going to want to look to other frameworks to help support that, but it's a huge difference because now we actually have a regulation in New York that says it's not just if you get breached that you can have liability. You could be liable if you're not taking proactive measures to protect that information. And so that's creating more liability and, frankly, the goal of encouraging companies to take this seriously before a breach happens and not after, frankly, the horse is already out of the barn and your data has already been exposed.
Yeah, no, that's really interesting. It reminds me what we have in Europe with the GDPR, the privacy by design concept, no? The fact to act proactively in order to avoid violation and breaches. And under this point of view, are there some points that similar or very different to other regulation? In particular, I'm interested to look at the main differences with the GDPR, that is one of the most important and most relevant, but also, of course, CCPA. And we know there are many other regulations popping up all around the United States and all around the world, of course.
That's true. It is always a fun day in privacy world because it feels like every single day is a new regulation or a new case or something like that. So it does have similarities that the language that's used in the New York Shield Act, you could almost align to the HIPAA compliance, right? Because it has that same language of like administrative technical safeguards, and also doesn't give like detailed guidance of what those need to be. It's more just they have to be reasonable. A lot of people, GDPR started an international conversation. I think that's a pretty commonly held concept. And it is impacting the way that the US is viewing this idea of privacy and what does it mean to provide privacy protections. I think where we see, and New York and CCPA diverge from each other, is that the California Consumer Privacy Act is very focused on this concept of consumers, which we see a lot in U.S. law. We're okay with regulating around business and consumer context because we're not necessarily at the level of the EU with this fundamental right to privacy. So we kind of focus more on this consumers. We don't see that same consumer language in New York, which is really interesting. They seem more willing to bleed a little bit outside of the consumer context, although, again, it has to be a business who's collecting data, who's doing that, unlike the GDPR, which is impacting every type of entity, and the only thing that's carved out is personal sort of household exemption under the GDPR. So we still see that carve out for nonprofits in both California and New York. We sort of see the carve out for data that's covered in other ways, very different from the way the GDPR is, which is meant to be more of that global data privacy protection act. But the GDPR, where we do see a lot of similarities in the US generally, is this idea of having rights around your data. And we can really thank the GDPR for that because it brought this concept into the United States. CCPA, I think Virginia, you can look to a lot of different laws that are maybe not on the books yet, but are pending, who are looking to include rights as part of it. And they typically have the right to access, the right to rectify information. Oftentimes in the US, we focus on this right to opt out of the sale of data, which is a little bit different than we see in the GDPR. They have rights to opt out, but it's more about processing generally. Whereas in the US, it's restricted to that idea, again, of like business consumerism, and that right is sort of tied into that. And then that right to delete data, which we see is analogous to the GDPR, although how we will ultimately end up interpreting it versus how the GDPR will, that's unknown, right? Because in both jurisdictions, I don't think we have a real concept of what it means to delete data. Does it actually mean to delete it, or does it mean to anonymize it? And if it means to anonymize it, what does that mean as compared to pseudonymization, right? All of these concepts. So I think we can see this impact of the GDPR, but the US is taking unique tilts on it, and part of that is because we just don't have, the GDPR is built on a fundamental right to privacy that doesn't necessarily exist in the United States.
Yeah, we face that's really interesting. Thank you, Jordan. We face something similar with our members in Asian jurisdiction, in particular in Hong Kong and Singapore, where they have a more business-oriented privacy system that, is still protecting privacy, but just in a different way, starting from a different perspective. And it's always interesting for me to see how differently the point of view can change from one country to another one.
And it's interesting. So just to pick up on what you said, but then you compare Singapore, Hong Kong to Japan, and Japan was the first country post GDPR to receive an adequacy decision that they're protecting privacy at the level necessary under the GDPR. So under Chapter 5 of the GDPR, you can now transfer data to and from EU and Japan, and you don't have to go through all those added mechanisms that you may need in place. So it's interesting because even if you look at Asia, right, we see the same conversation going, which is this idea of, is privacy this driven from consumerism and economics, or is privacy a fundamental right? And where you start in that analysis is going to drive where you ultimately go with your regulation.
Yeah, definitely. Thank you for this point. And let's go back a bit more on the New York Shield Act. I would like to ask you, are there parts of it or provisions on it that, worries you as a lawyer? In particular, considering your practical experience, I think you may have an idea on which parts of this act may create more issues for your clients. Are there parts of it that you are particularly worried about?
So I wouldn't say there's parts of the New York Shield Act that I have almost like a visceral reaction to. Like, this is going to be unable to comply with. I think the challenge in the United States right now is that many of my clients operate in all 50 states and also internationally. It's not uncommon for an American company to do work in the UK, in Europe generally, in Canada, all 50 United States. And so right now I have clients who are saying to themselves, another regulation in another what I would consider a powerhouse state, right? A huge economic area. People want to do business there. There's a lot of people there, right? The finance industry is huge in New York. And so we have another jurisdiction, another regulation they have to comply with. And it's almost getting to the point where it's like, I'm going to throw up my hands, because how do I actually comply with 50 different regulations and the GDPR and PIPEDA and deal with the fact that Brexit is going to make the UK be outside of the EU? It's almost like, if I can't do this, and if I can't figure out a way to do it that's economical, that uses my resources effectively, they're almost inundated. And they feel like they're opening Pandora's box, and they don't want to open that box, and so they'd rather just put their head in the sand. So for me, the struggle is making companies understand that there are similarities, right? We can tie things across these regulations, and we can map GDPR, CCPA, New York Shield Act, the new Virginia proposed regulation, anything that comes down the pike, we can map it. Because most of these, while having some nuanced differences, and I'm not going to downplay that, those differences can sometimes very much matter, but they're all built on similar privacy concepts, right? So if you're doing good, if you're telling people what you're doing with their data, and you know who you're giving access to that data to, you're already hitting so many components of these. So it's more just getting the message out there that this is not another privacy regulation. You generally need to be taking privacy seriously. You need to be taking security seriously. And part of taking it seriously is being aware of these regulations, but it doesn't mean that you have to exponentially increase your burden under privacy. It just means that you need to be thinking about it thoughtfully and actually taking it seriously. Like making this a C-suite level item, making this a budget line that you're going to have to address, right? It's not going away. As much as many people would hope it might go away, right? It's not going away, but there's ways to think about it that it's not going to become overburdensome. So my struggle with the New York Shield Act and with any like state act is that they feel like it adds to their burden instead of recognizing that there's ways to handle it without completely like blowing up the entire system that you have.
Yes, definitely. No, I totally agree with your points, Jordan. In particular, the fact that even if the jurisdiction and the regulation are different, there are some principles that you can always find in each of them, because at the very end, privacy is always privacy, and this concept can change under some point of view, but the main one is always the same. So,
and it always starts with the same question: what is your data, and what are you doing with it? Under every privacy regulation, if you can't answer either of those two questions, then you're not going to make it anywhere, right? Like, you need to know what data do you have and what are you doing with it. And that's going to get you so far along with all of these regulations that and they sound like simple questions. They're actually quite difficult to answer. But they're the first questions under any privacy regulation, because it's the only way you can know, am I even impacted by this? Do I have to comply with it? And then if I have to comply with it, what does that mean? All of that analysis is going to be driven by what is my data and what am I doing with it?
Yes, definitely. Totally agree. And Jordan, let's move now more on, let's say, the case related to privacy, the sector of the cases. Are there cases related to privacy that you would like to discuss that are interesting also in relation to what we just discussed today?
So many of these regulations are very new, so we have not seen them be tested yet in court. However, there's two cases I'd like to mention specific in the privacy context. And the first one is a case out of Pennsylvania, and it's called Dittman versus UPMC. So Dittman was influential because it was not based on a regulation. It was pure case law. So in the United States, a common law jurisdiction, we can have both regulations that are going to dictate what entities have to do, and then we can have case law and general common law that entities have to follow, right? So we have these sort of two bodies of law that we can look to. And then you compare that to the civil law, which is much more regulation driven. So when you're looking at Europe and et cetera, especially the continent of Europe. But so Dittman versus UPMC was a case that went up to the Pennsylvania Supreme Court. And the case dealt with a security breach that occurred at UPMC where employee data was taken and then was used to file false tax returns, to steal identities, etc. So we had actual use cases of the data that we could point to. So there's a class action lawsuit that was filed by these UPMC employees against their employer. And the reason this was so influential is because the Supreme Court said that UPMC, by virtue of collecting data, owed a duty of care to the employees. Basically saying, you're going to have a responsibility to protect that information and that data because you collected it, right? And they didn't say because you're an employer and employee. It said you collected data, you owe a responsibility to the individual whose data you collected. And so it was very influential because now we have this idea, at least in Pennsylvania, that if you're collecting data, you owe a duty of care. And a duty of care means you have to take those proactive responsibilities around that information to ensure that the individual's information is at least reasonably being taken care of, right? So that's a really influential case. It came out a year or so ago, so it's still working its way through the case because they remanded it back. But it's something definitely to watch because I think, at least in Pennsylvania, it shows this level of care you have to take, and now we actually have a case that people can look to in regards to that. So that's the first case. And the second case that I'll just briefly mention, and this is a very, very recent case, it comes out of the Northern District of California. It's Barnes v. Hannah Anderson, LLC. And it was just filed in the beginning of February of this year. And this was dealing with a breach of information. So a common thread that we see in case law is that oftentimes companies get into court because of breaches, right? So it's not necessarily the privacy violations up to this point that have driven the cases. It's been more, I have a breach and a breach exposes all of these bad things I'm doing, and now people are going to sue me for all these bad things that most likely led to the breach, but maybe outside of that as well. And so what we have in the Hannah case is an individual is suing another class action lawsuit, and they are claiming that the companies, and it's Salesforce and a clothing company, failed to take appropriate measures with protecting their information. So pretty standard case. But why I mention it, it's something to be aware of and to be watching over the next couple of months, is it's the first case that we see the California Consumer Privacy Act is expressly mentioned and being used to support their argument that the company failed to take reasonable privacy measures and violated the California Consumer Privacy Act as it related to the data that was breached. So it was literally just filed in the beginning of February. It has I am sure we are going to see a plethora of motions filed on this case, etc. But it's really influential because a lot of people are waiting to see how much bite these regulations are going to have. And you have to be remembering, with the regulation, we have both, are you violating the regulation, and can the Attorney General come in and fine you for that? But then also, do the regulations create causes of actions that we as individuals can use to file lawsuits against companies? So when you're thinking about a regulation, it can be used in a couple different venues, and you need to be mindful of that as a business. Where could I potentially have liability under this regulation? And the way that these are being drafted, they're giving multiple bites at the apple of liability for these companies, unfortunately.
Okay, thank you. That's really interesting. In particular, this new case that he's mentioning, the CCPA, is just the start. It's the beginning. So let's see how it goes. And Jordan, we are running out of our time. I just would like briefly to ask you, is there any advice that you would like to give to people that would like to have business in New York or that already started or want to start a business there?
So I would say start the privacy conversation and the security conversation as early as possible. The easiest time to comply with the law is before you have the data, right? So after you've collected all this data, it's going to require you to go back and review why you have it and get consents and all these lawful bases and provide notices. So the easiest time, especially if you're a startup, the easiest time to deal with privacy and security is early on. And we're not talking that you need to go out and pay for a $500,000 infrastructure. You just need to be having it as part of your daily conversation. Are we taking privacy into consideration? Are we taking security into consideration? Are there choices we could make that from a business perspective, everything remains equal, but from a privacy perspective, we can increase somebody's privacy? And those are things that are required under the GDPR. We're starting to see them be required under US law, and it's just good business practice. You know, I hope that one day individuals will choose companies that they want to interact with based on their privacy and security. And I think that as a society, we're driving that direction. We're not going to get there tomorrow. We're not going to probably get there in a couple of years, but we're driving that direction. So in the end, it will, you know, privacy oftentimes gets seen as like, we have to do privacy. We have to do security. But I actually think when done correctly can be used to promote your business. It can be a differentiator. We take you seriously. You want to buy from us because we take your data seriously. We take this seriously. And so I would say the earlier on you can have those conversations and start thinking about this, the easier it's going to be. And don't wait until March of this year to start having this conversation, because the day the regulation goes into effect, you are already behind, and you don't want to be behind when it comes to privacy and security.
Definitely, I totally agree. So Jordan, thank you very much for your time and for being with us today. It has been a great pleasure speaking with you and knowing more about this Shield Act. And I really hope to hear from you very, very soon again, and best of luck with all your activities.
Thank you.